Hello, good morning. Welcome to the second panel of today's colloquium, which is called Collective Redress. When I was being asked to preside this panel, I understood it's supposed to be Schrems bashing, but apparently it's not only that. So there will be something more than just accusing the court and this poor Advocate General in particular that he doesn't like consumers. I mean, I do like consumers, and that one being out of the way, I'm very happy to engage in substantive discussion or whatever you like. But I'm here to preside and above all, give the floor to our speaker and the discussants. We have one main paper and two discussants. The main paper by Cinzia Peraro from the University of Verona is on cross-border collective redress, horizontal versus sectoral approach. We did democratically, sort of, agree that the main speaker would have 20 minutes and then the discussants each 10 minutes to come back and react. And afterwards, the floor is open for discussion. So, please, the floor is yours.
Thank you very much. So, thank you very much for hosting me at this really horrible colloquium. And thank you to Mr. Chairman. So my presentation focuses on cross-border collective redress, as already said, horizontal versus sectoral approach. But I will focus in particular on this aspect, jurisdictional regime. Is the Brussels regime fit for purpose? And I try to give some answers, not just one, it's quite impossible, as I already commented. And my analysis will start from the notion and context of collective redress in the European Union, and then the two approaches I identified, and then I will move on the jurisdictional regime. So first of all, what is a collective redress? And we found this definition in the Commission documents and initiatives, where it is defined as a procedural mechanism in the form of a representative action. It is aimed at facilitating access to justice and strengthening the negotiating power, and also to avoid numerous and parallel proceedings when the same infringements of law and the same infringement and violation of rights granted under union law. In general, this is a means, and it is considered and conceived as a means for an effective and efficient enforcement of rights granted under union law. But why is there a need, or is there a need of a collective redress at a European Union level? And if we have a look to the last decades and the mass harm situations that are increasing in transnational context due to different factors, and for instance, the greater use of internet and the online shopping, online transactions, and the various scenarios that involve a number of individuals suffering the same violation, and as occurred in the car emissions case. So then there are other cases involving passengers' rights, always in the categories of consumer. And I want to underline this aspect from the beginning. Then I listed court of victims, environment, employment, and discriminations. So the actual contents appear to call for a European action when European Union law is concerned, and when the violation of rights granted under European Union law is claimed. And against this background, I would like also to point out the practical relevance of collective mechanisms. Because it is true indeed that low-value claims are hardly brought before the courts, and also for the length, costs, and complexity of litigation, mainly abroad. And then collective judicial mechanisms at national level and then at European Union level must offer legal certainty, not only for claimants, but for defendants and the judicial system, to avoid, as already said, parallel litigation. But which are the obstacles? We have different legal systems, different legal traditions, and this goes and may hamper the idea of achieving a high level of uniformity of our national procedural systems. So, as also stems from the 2007 studies on collective redress in in member states' legal orders, these are mainly made available to consumers. However, but only in other few cases we see also that they are made available for workers, and this is an aspect that I will focus on later on. Then another obstacle is this, the procedural autonomy of member states, and that the European Union action must observe and respect the principle of subsidiarity. So on the one side, we have the protection of national identities vis-à-vis the protection of individual rights granted under European Union law that may be better protected and enforced in a collective dimension, in a collective procedural mechanism. What has been adopted and proposed so far at the EU level? So we have the Commission activity started early in 1993, in the 90s, and there are a lot of soft law initiatives tackle the issue of collective redress that try to understand and assess the national systems on the one hand, and on the other hand, the opportunity to establish a European collective redress. And then we have sector-specific legislation that introduce collective remedies or call member states to provide as an effective remedy a collective procedure. And all these acts may be considered in these two separate categories I've already said. The two different approach, the horizontal and the sectoral approach. This twofold approach may reflect the uncertainty in the determination of a European action in this field, and that the inconsistencies of the approach adopted by the Commission. These inconsistencies have been already pointed out within the 2011 public consultation in the process that led to the adoption of the communications of 2013 and the recommendation of 2013 of the same date. Indeed, the Commission itself admitted that it deliberately adopted a balanced approach by issuing in 2013 a horizontal recommendation and a proposal for antitrust damages actions. But on the other hand, committed itself to take a horizontal approach. So this horizontal approach was deemed to avoid the risk of uncoordinated sectorial European Union initiatives. As to the horizontal approach, as already mentioned, I put in this category the communication and the recommendation of 2013. They relate to and they established common principles. And these common principles are meant to be as minimum procedural standards to be implemented at national level. And with this common principles, thanks to this horizontal approach, the alignment of national systems on some central issues regarding collective redress may be achieved. I'm sorry, I need to move. And the two different forms of collective redress have been underlined with injunctive and compensatory forms. What I would like to point out is the scope of application of these common principles, because it is said that collective redress and these principles may be applied in various areas where collective redress is of value or would be relevant. Although we have some areas and some fields that are all related to consumer protection and competition, environmental protection of personal data, financial services, and legislation and investor protection. But, I'm sorry, I need to move back. But this recommendation is a non-binding act, and it had a limited impact on national system, as described in the report and studies on the implementation of this recommendation. And the principles left flexibility and discretion upon member states to provide some exceptions already to these common principles. And then another aspect that was argued is the application of these principles in transnational disputes or only in the national context. So, in the optimistic scenario where all member states did fully implement the recommendation, the harmonization between and among member states would be achieved. But in the negative reality, according to the 2018 report on the implementation of the recommendation, not so many legislative developments and progresses or acts have been adopted. So the harmonization has not yet been achieved. And this horizontal approach, I try to pointed out few advantages, and I think that these principles could result in an added value to the national systems and granted similar standards across all EU member states. They may facilitate litigations abroad, and indeed all these common principles have a broad scope of application, and they are not limited to one area. But this has also the other side of the coin, because the peculiarities that characterize certain sectors may be undermined, and specific rules should be introduced. And this brings me to the sectoral approach. As mentioned with regard to the path towards a European Union collective redress, several initiatives have been adopted and tackled this issue, especially in relation to consumers and antitrust law. Legislation is mainly based on Article 114 on the approximation of laws for the smooth functioning of the internal market, but it's not complete, and it does not cover procedural requirements. The directive on the antitrust damages actions did not cover these procedural requirements, and above all, it did not impose member states an obligation to introduce a collective redress. Then we have this, the latest and recent proposal on representative actions for the protection of collective interests of consumers that is aimed at defining a union, at union level, a common framework for representative actions and for infringements of union law arising from domestic or cross-border transaction in a variety of sectors, such as, and they are listed, data protection, financial services, energy, telecommunications, health, and environment, where this variety of sectors, they are always linked to the category of consumers. And moreover, in this proposal, under Recital 24, this framework is not meant to replace the national legislation on collective redress, but member states are required to design a representative action as an alternative mechanism or to integrate their national legislation. I think that this sectoral approach has the advantage to create a framework tailored to the specific categories, which so take into account the specificities of the category and the legal tradition of the member states. So I would like to consider this approach as a step-by-step approach. It allows to see the impact of a European action on these specific procedural mechanisms in national legal orders and the reactions of member states in a specific field and not in general in the civil procedural law. But collective redress may be also a useful and an effective remedy in other sensitive policies. And I think that employment could be a good example, and because we have forms of representative actions in some member states. We have trade unions acting on behalf or in support of workers. They are also as weaker parties as consumers are. So it's thus significant to evaluate, even if in this context, in the context of the protection of workers, collective redress could be an effective remedy, and if possibly, legislation could be developed in this field. In the relevant legislation concerning employment, there are no clear and no express mention to collective redress, but we have the right to collective action. That is granted under the Charter, Article 28, and this general clause on the fact that on the obligation upon member states to respect the right to collective action is included in all the relevant legislation. Also, in the framework, the legislation adopted in the framework of the Free Movement of Workers, Directive 2014, number 54, and also in the framework related to posted workers. So, as to the first directive of 2014, number 54, here we have, I would like to point out that under Recital 15, member states are invited to examine the implementation of common principles for injunctive and compensatory collective redress mechanisms. This is a clear reference to the 2013 recommendation, even if it is not expressly mentioned. And such a statement is not mentioned in the directive on antitrust damages actions and of nearly the same period, nor in the consumer legislation. Also, in the legislation on posted workers, we have references to the right to collective action without any procedural requirements. So, as I wanted to show you, is the fact that also this sector may reflect the opportunity to develop a collective redress also for workers, for the protection of workers' rights. But no initiatives or proposals have been submitted so far. So moving to the cross-border context, I found that no specific private international law provisions related to transnational collective redress are included in private international law regulations and in the horizontal framework I've said before, and neither nor in the sectoral legislation. With regard to private international law regulations, it is worth noting that within the process for the recast of Brussels I regulation, discussion and debates from stakeholders raised the point of the recognition of collective judgments and the abolition of the exequatur. What I want to underline is that the Commission at that time answered that the required level of trust cannot be presumed at this stage, and reported that this issue of collective redress was under discussion and under public consultation because of the then adopted 2013 recommendation. With specific regard to the jurisdictional regime, there are some considerations that I would like to point out. First, cross-border cases have been considered in this recommendation on common principles, and we have two paragraphs, 17 and 18, which stated the mutual recognition of the status of foreign representative entities. That, however, relates only to admissibility and legal standing of those entities, and this principle does not prevent the risk of forum shopping. From a positive perspective, these principles try to overcome difficulties in instituting proceedings abroad. The courts of member states are required to recognize foreign representative entities. In the communication also observed in the accompanying communication of 2013 that the Brussels I regulation should be fully exploited and thus postpone the assessment of the need to introduce specific rules on jurisdiction. But this principle, however, in my view, it does not answer the question on which court has jurisdiction over collective redress. And then I move on the case law on assignment of consumer's claim. Now I'm a bit afraid, but
And
so
I wasn't about to show 5 minutes because you got two shrimps. Okay.
okay.
That's
I can
completely
skip,
independent. No, please don't.
but just few considerations.
Of course.
Because the Court of Justice and Advocate General pointed out that Brussels I regulation could not be extended to cover collective redress. But first, the few cases regarded not collective redress properly, because under national law, they were assignment of claims. And then the question was the applicability of the existing Brussels I regulation to the assignee. But since Articles 15 and 16 on the special protective fora for consumers are derogations from the general rule, they cannot be extended to cover other situations falling outside the scope of application of the regulation. So Brussels I regulation could have not been applied. So that's why I went quickly, but I would like to move because I think that there are other situations at the legislative level that form and constitute a collective procedure. And first of all, I pointed the attention to the GDPR, where under Article 80, there is an extension of the special fora for the representative action for the representative organization that act on the basis of a mandate of the data subjects. And this is thus an extension of the application of the fora established thereof. And then the recently 2018 proposal on the application of the existing private international law regulations to representative entities. In Article 16, first provide and states the mutual recognition principles as already mentioned in the 2013 recommendation. But then under Recital 9, we can read that the application of the existing private international law rules on jurisdiction, recognition and enforcement of judgments and applicable law is possible to such representative actions. This is contained in a Recital 9, and it's not as a binding article, but at an interpretative level, it follows that representative entities may invoke all the special protective fora established under regulation, under Brussels I regulation. Is this the application of the existing private international law regulation enough? I think that there are still unsolved. This is not enough. I think I have some questions on how this extension works. So, but at the moment, I will move and remain at a general level and ask myself whether this extension of application may be applied analogically to other matters. And what about not in matters falling in deployment law? So if the Commission proposed to extend the application of Brussels I regulation to consumers, why it cannot be applied analogically to these principles to workers as well? And we have a few cases involving trade unions that also have been addressed to the Court of Justice. They related mostly to the protection, to the exercise of the right to collective action vis-à-vis economic freedoms. And we have one case, sorry for my pronunciation, Sakolajonen Amatilito, a Finnish trade union, that it did not concern the jurisdictional regime, but the applicable law to the trade union acting in front of a Finnish court. In that case, the Polish undertaking claimed the application of its law state of origin to the trade union. and claimed the fact that the Finnish trade union could not represent also posted workers that were Polish. So I put some questions, I think. I tried to put some possible solutions. And first of all, the introduction of provisions on cross-border issues related to collective redress, or in the horizontal framework, if it will be developed in the future, or in the sector-specific legislation, or in the private international law regulations. Or we can have the introduction of a provision on the extension of the application of the existing private international law rules. And finally, also, we can, why not, introduce tailored specific connecting criteria for collective procedures. And some stakeholders already in the past public consultations pointed out that probably a new general factor could be the domicile of the majority of the claimants. I do not think that this could be possible solutions because of the residual part and the protection of the residual part of this group of claimants, the protection and their right to defense, or the possibility to have the decision enforced and recognized in their home state of origin. I move quickly to the conclusion and to say that I think that there is, yes, an inconsistency between the two approaches, but maybe justified on the fact that the European Union does not retain exclusive competencies and that member states, on the other side, are not willing, and they want their national legal traditions to be respected. So the horizontal framework is too far-reaching, maybe, because also we assisted to the limited implementation of the recommendation on common principles. And the sectoral approach seems to be the most feasible solution in practice. What I want to underline is that collective redress could be really an effective and efficient means for enforcement of rights under Union law, of rights granted under European Union law. Moving to my first question, so is the Brussels regime fit for purpose? I cannot hide the answer, so the answer is no for me. Because it governs individual disputes. And to allow an extension, probably more deeply and further consideration must be done. Then the proposed extension of the existing private international law rules, I think that also this extension in somehow differs from the findings we see in the case law of the Court of Justice related to assignment of claims, where also Advocate General affirmed that there is a need of comprehensive legislation and judicial legislation would be inappropriate. But I think that in this 2018 proposal, we find a follow-up answer from the Commission at the legislative level, and that opinion was like a motion for a legislative intervention. So what about future developments? I think that we shall have an eye on the legislative process, on these proposals, on representative actions, and on potential case law. And I remember the pending case Fashion ID. It regarded data protection, but relating to the previous, the then applicable Directive 1995. I then think that the idea of a common European framework should not be abandoned. And what already the Commission stated in the past, more efforts by member states should be implemented to enhance the level of mutual trust, also in this field, in the procedural field. Thank you.
Thank you. Thank you very much indeed. I'm still not sure whether that picture is encouraging or threatening, but that's a question we can actually address to our discussants, actually. So we have two reaction papers / presentations. The first one by Stephanie Law from the Max Planck Institute here. Please, the floor is yours.
Just be careful not to fall. So, okay. So thank you very much to the organizers, and especially Professor Hess for asking Janek and I to make some comments on Cinzia's paper today. In light of the paper and presentation, Janek and I thought that we might try to tackle further the cross-border dimensions of collective redress, taking up in particular, as was already mentioned, the most recent initiative of the European Commission, the 2018 proposal on representative actions, as regard the enforcement in particular of EU consumer rights, and by examining its purported or intended, at least by the European Commission, correlation or integration into the framework of Brussels 1 bis. As you will see, Janek will then go on to examine some issues with recognition and enforcement, particularly with regards to public policy. And finally, we will draw some conclusions, leaving lots of scope for additional food for thought and asking whether the time is ripe for the amendment of the Brussels 1 bis regulation as regards collective redress. So, as has already been mentioned, the existing of long-standing discussions on collective redress and private international law have been ongoing for the past 10 years at least, and the various types of mass infringements of EU law that might arise have been mentioned. So to very briefly summarize, there has been discussion over the various problematics of cross-border consumer redress, none of which have really ever come to fruition. So as a result, there's a disparity between the discussions ongoing and legislated outcomes, with neither the instruments in collective redress nor the Brussels 1 bis regulation providing for rules on jurisdiction for cross-border collective actions. So indeed, what we have at the moment is a lack of coherence between collective redress and private international law rules on the one hand, and a diversity of collective redress mechanisms across the member states on the other. And as is also the case, no real coherent definition of what collective redress actually means, alongside this absence of a coherent private international law framework. So I won't engage in any Schrems bashing, of course, but these issues were highlighted by the Advocate General Bobek in the Schrems case, in which it was further asserted that the step towards coherence can only be taken by the union lawmaker. Indeed, Advocate General Bobek mentioned the dangers of judicial legislation and the need for comprehensive legislation by the lawmaker, not an isolated judicial intervention. Moreover, he commented on the fact that at the time that the decision was rendered, the opinion and the decision was rendered, the union lawmakers were already engaged in deliberation and discussion, which should not be preempted by any effort on the part of the judiciary. And it's to the fruits of this discussion that I will now turn. So in April 2018, some 3 months after the Schrems judgment was rendered, the European Commission released its proposal for a directive on representative actions as part of its new deal for consumers. The key dimensions of this proposal have already been mentioned, but I will just reiterate very briefly. It aims to provide for a mechanism for domestic and cross-border representative actions for both injunctive relief and redress, including, for example, compensation, repair and replacement, price reduction, termination of the contract, reimbursement of the price paid, on an opt-in basis. Representative entities must be qualified and monitored within the member states, which is to say they have to be properly established, have a not-for-profit basis, and have a legitimate interest in ensuring compliance with EU law. Finally, redress is only available after a two-step procedure. First, there must be a final decision on the existence of an infringement, and only then can a redress action be brought. As regard cross-border representative actions, the proposal provides for the maintenance of the rules on Brussels 1 bis, as we have heard, and is otherwise silent as to issues of jurisdiction and parallel litigation. It only provides for rules of mutual recognition of representative entities, providing in Article 16 that member states should ensure actions can be brought before competent courts or authorities of member states, either by several qualified entities of different member states acting jointly or represented by a single entity. So to clarify before proceeding, what we understand cross-border representative actions to mean is an action encompassing multiple injured parties, here consumers, domiciled in different member states and sharing the same cause of action against the same defendant, where litigation is conducted by the representative or qualified entity. So we try to formulate our presentation or comments looking at different sets of problems, two of which in particular concern jurisdiction. So the status of the representative entity and the legal position of the individual members of the class. So first, two general points should be made as regard the regulation. Firstly, as we know, it's predicated on cross-border litigation arising between two parties. And secondly, the relevant connecting factors pointing to jurisdiction are based on the notion that the litigating party bringing the action does so in his or her own interest. As we shall see, each of these characteristics might clash with the idea and feasibility of collective redress in a representative action model. So as regards jurisdiction, our first port of call, of course, is to look at the general rule of jurisdiction in Article 4, which points to jurisdiction in the courts of the domicile of the defendant, or per Article 1, as we know, which is strictly interpreted, limited to one of the domiciles where there are multiple defendants. Indeed, it's been suggested that in relation to collective redress, this should be the only rule of jurisdiction, it being the only forum in which all of the actions can be consolidated. And a preliminary point that can be made is that this basis of jurisdiction may not in itself be negative. It points to certainty and predictability, objectives of the regulation for all parties involved. However, from the perspective of the consumer as a class member, we might ask if we can rather look to other bases of jurisdiction. Some of the reasons why we might do so concern the typical problems faced by consumers in litigating: time and financial resources, raising the question of whether there exists effective access to justice for consumers who are obliged to go to the court of the defendant, and accentuating the lack of proximity between the harm suffered by the individual consumer and the place of litigation. Even in the case of representative actions, we know that these issues of resources might be less significant, but it's worth raising. So we also ask from the perspective of representative entities, where jurisdiction is consolidated in the domicile of the defendant, whether issues of resources might not arise for those representative entities. So we can take, for example, member states in which there are large defendants. We can look at Luxembourg, for example, with Amazon, or Ireland with Facebook. And against this background, I will turn to look at some of the special heads of jurisdiction, recourse to each, as we will see, give rise to a number of problems. So the first is that of contract in Article 7.1. Here, from our problem-oriented approach, the status of the representative entity is the key challenge. So the Court of Justice case law on the issue is rather strict, as we've heard. The court has confirmed that the notion of matters relating to contract in Article 7.1 requires the existence of an obligation freely assumed by one party to another. So therefore it becomes necessary to ask what kind of legal relationship exists between the litigating parties, i.e. between the representative entity and the defendant. To cut it short, we assume that there is no assignment of claims between the parties, between the consumer and the representative entity. And as such, that there is no obligation freely assumed by by the representative entity to the defendant. Even if, however, we could look to the assignment of claims between the consumer and the representative entity, such that a contractual relationship does exist, difficulties with connecting factors nevertheless arise. And moreover, as we've heard, assignment does not change jurisdiction. So as we know, Article 7 is based on the notion of proximity and a territorial connection between the court with jurisdiction and the place of performance. That is, the place where the goods or services were delivered or provided or should have been. As regards collective redress, we have identified two key problems which arise in determining the place of performance. As there will be, on the one hand, as there will be multiple consumer parties who have contracted through multiple contracts for performance in different member states, more than likely that of their domicile, there are multiple places of delivery and provision of services. On the other hand, the issue becomes even more complicated when we consider that this multiplicity of places of performance might arise within one national system, resulting in a fragmentation of jurisdiction within one system. So we ask, how could this problem be resolved? How could this head of jurisdiction be extended to deal with representative actions? A principal delivery or provision of goods or performances might be adopted, determined by economic criteria, for example, identifying the center of gravity in respect of the place where a majority of consumers have contracted for performance. Alternatively, a center of gravity approach might be adopted where the courts of the place of the main provision of services can be identified. And a further choice would be to allow a choice by the representative entity, as in the case of flight cancellations, where there's deemed to be an as close a connection between the two fora. So, a preliminary conclusion with regards to Article 7.1. There are, of course, numerous difficulties with identifying the place of performance, even if there can be said to be a contractual relationship between the representative entity and the defendant. So before examining the issue of tort, I will turn first to the protective jurisdiction afforded under Article 18.1. So Article 18.1 provides for certain criteria which have to be satisfied before it can be engaged. One party has to be a consumer acting outside of his trade or profession. There must be a business-to-consumer contract falling within the scope of Article 17.1. Then, if these criteria are satisfied, the consumer can choose whether to bring proceedings in the courts of the defendant's domicile or the courts for the place where he or she is domiciled. So, as regards representative actions, two key questions arise. The first we've already discussed, whether there is a need for a contractual relationship. And the second, even if this contractual relationship does exist, whether it's appropriate in light of the protective purposes of Article 18.1 that a representative entity can rely on this extended jurisdiction. So this issue, of course, has already been raised in a number of Court of Justice cases, most recently in Schrems, in which the court followed its existing case law. And we can really ask whether representative entities should be able to should be considered as satisfying this criteria of the weaker party with a lack of bargaining and litigation power. So the court, of course, suggests that in Henkel, the representative entity should not be able to rely on this jurisdiction. The alternative, as we've heard, is that Article 18.1 might be extended to encompass representative actions by understanding consumers as a member of the class and a beneficiary of the representative action. Something similar can be seen in Article 80 of the GDPR, but I'm not sure that I agree that we can see the same extension in the 2018 proposal of the Commission. Nevertheless, we know that issues of proximity, certainty, and predictability will still arise. So, thirdly and finally, for my part, we can turn to consider the relevance of Article 7.2, which attributes jurisdiction for all actions which seek to establish the liability of the defendant and which are not related to a contract to the courts of the place where the harm occurred. So as we've heard this morning, Article 7.2's relevance for actions brought by representative entities, in particular by a Consumer Protection Association, has been confirmed by the Court of Justice in Henkel, in this case concerning an action for an injunction to prohibit the use of unfair terms. A number of issues nevertheless arise with regard to the relevant connecting factors under Article 7.2, particularly as regards the place where the causal event or emission occurred and the determination of the place where the damage is sustained. So the key problem in collective consumer redress situations is in determining the place where the damage materializes, where the place of the event or the emission will usually correspond to the domicile of the defendant. The place of harm in cross-border collective redress will be various, where we have multiple consumers harmed in different member states, and even, as we mentioned before, within the same member state. So as a result, and in light of Cheval, we know that multiple claims might only be consolidated in the courts of the place of the event giving rise to the damage, corresponding to the defendant's domicile, most usually, and where the action can be brought for all damage regardless of where it has been suffered. In the alternative, looking to the courts for the place where the damage materializes allows only for an action for the damage materializing within that jurisdiction. A fragmentation that is exemplified, we can imagine, where there are multiple consumers suffering harm in different places. So how, again, might this problem be resolved? Different approaches have been advanced. It's been suggested that a center of gravity approach might be adopted, identifying the center of gravity as the habitual residence of the majority of class members, extending the approach in e-date to allow for jurisdiction in that court for damage incurred anywhere. This would also allow for potentially the reduction of fragmentation of jurisdiction. However, we find some criticisms in the academic literature, which we can come back to in the discussion. So finally, for my part, very finally, we find two options of jurisdiction. We come back to the first point we raised, the domicile of the defendant, and the second, the place where the harm materializes or may for the majority of class members. I won't reiterate the number of problems that arise that I've just discussed, but for the moment, I pass the floor to Janek, who will discuss recognition and enforcement.
So, thank you very much, Stephanie. I will build upon your analysis. If you look at the options, if you just look at limited changes, like we should extend it a bit or adopt certain connecting factors, like changing the notion of relation to contractual matters to sort of accommodate representative entities to take recourse to this kind of jurisdiction, in the end, you would more or less always come to the same conclusion, is that it's either the domicile of the defendant or, given the specific connecting factors, nevertheless, you would end up in the domicile of, let's say, the interested party, thinking that the damage will occur at this domicile, or the contract or the service performed at the domicile. So European-wide class consolidation is actually not possible. So you remain fragmented even if you would embark upon these changes. Maybe in some cases you might come to better results, but largely not. So you would need more radical changes to the Brussels regime in order to basically accommodate European-wide collective redress. And this would be altering the balance, actually, of the whole instrument, because you would go more or less from a proximity criterion to more of a focusing on where could the administration of justice be more efficiently secured. For example, the center of gravity. If you have multiple places where harm has occurred, you centralize where the most harm has occurred. But that means, of course, that certain victims will be deprived basically on the protection that exists now. And more or less, individual litigation will always still be possible. So you would have like various problems that would arise from that approach if you would only purely focus on the need to make collective redress efficient, because there will always be an individual litigation possible as well. You might even end up with more possible jurisdictions than there are now. Which means that there might be more need actually for, there might be more decisions actually outside the current localizations, and there might be more circulation needed, which also gives rise to potentially more issues of recognition enforcement. And this especially we consider in relation to collective redress, because we do not have a common understanding of what collective redress is, what are the specific mechanisms are, nor actually of collective redress existing at all. As we've seen in the latest evaluation, compensatory collective redress is available in only 15 member states. And then in those member states, approaches differ considerably. That's why I think it will be very unlikely that the Commission proposal will be adopted. It's also then likely that we will continue working with these different mechanisms of collective redress amongst the member states, with different guarantees, different conception. The question we need to ask, do we then already need to change Brussels I, basically, in order to facilitate somehow collective redress, while these mechanisms are so different and may then lead to other problems? Public policy, irreconcilable decisions, because if the idea of Brussels I is to make decisions circulate freely, this might be a problem in this regard. So I look at recognition enforcement, presumably mostly public policy and irreconcilable decisions, etc. from this perspective. Now, if we look at the concept of public policy, it is in principle a national concept, but it has been largely Europeanized under the auspices of the right to fair trial, Article 6 of the Convention, Article 47 of the Charter, and we come out to a common conception of what this means, fair trial, what are procedural rights, what are the procedural guarantees. And that's also why we do not easily allow for the public policy exception. So there's quite a high standard, because we have this common understanding. We require really a manifest breach of a fundamental principle, not just any deviation. So there is a limited application with the objective of making judgments circulate. Important also, assessment by the national judge, of course, controlled by the Court of Justice, the framework at least, but the ultimate assessment lies with the national judge. And why do we trust the national judge in that regard as well? For the same reason why we have this very wide approach to circulation, is that we have a common understanding amongst the member states of civil procedure, centered essentially on two-party proceedings with all the procedural guarantees that come with that. And they have developed through years, decades, even centuries, and we've converged to a common standard, a common understanding in Europe of what actually is fair trial, of what actually is the procedural guarantees that should accompany trials. And therefore we allow circulation, and the focus is mostly not on procedural design then when it comes to public policy issues, but is more about the actual application of the safeguards in the specific case. So a harmonized approach with a limited public policy exception, with exceptional refusals, and of course the key is mutual trust in each other's systems, which is sort of the result of this idea that we believe that there is a common standard that we've all agreed to. Now, the question is whether this is the same for compensatory collective redress. I've pointed already out there is no general availability of compensatory collective redress amongst the member states. Almost half of them do not have it. And if you look at those who have it, the idea of how it's being delivered is fundamentally different from the different models: representative action, group actions, assignment of claims, etc., but also the procedural guarantees that come with it vary quite considerably between the member states. So the choices they make in sort of protecting the right to fair trial within the concept of collective redress is quite different. Think of notification, think of selection mechanism, etc. And to me, that has raised the question, do we have the same level of mutual trust when it comes to collective redress? The Commission, for example, in its proposal for the weakest was saying we do not have that, so maybe we would be stricter there. So do we have the same degree of mutual trust? If we argue that mutual trust and the permissive stance toward other systems the result of common traditions, a common understanding, a common concept of what procedure, what fair trial is, then this might be in doubt. And so I was wondering, can actually public policy then be used to a certain extent, to a degree that is gives courts a bit more latitude to check actually on the recognition and enforcement of foreign collective redress decisions. And so look both at, because a lot of member states do not have compensatory redress, I looked at refusal per se of merely analysis of procedural design. I think when it comes to collective redress per se, I don't think there is a problem. While there's quite old case of European Court of Human Rights, where the issue whether a collective mechanism actually detracts from the right to a fair trial, and then the court said, while restrictions are possible, provided that they are necessary, there's a legitimate interest, and that they are proportionate. So this raises issues of really procedural design. So Article 6, Article 47, they do not impose the model of two-party proceedings as such, but somehow the procedural guarantees will be benchmarked against actually the initial concept, which is two-party proceedings, because that is where the benchmark lies. And then the question is, how far can you deviate from it before it becomes problematic? So I think there could be no refusal per se, and that you would have to look actually at the actual design of class collective redress mechanisms and the procedural guarantees laid down in there in the different member states in order to secure a proportionate deviation, as one may say, the right to a fair trial, because collective redress does not exclude the right to a fair trial. So you would need safeguards, actually, in order to protect the interests, the right to a fair trial, both on the defendant side and of the interested parties that will be represented in the collective procedure. So Michal and Hodges have pointed this out. You have different ways of securing that. You have substantive controls, sort of limited to certain areas like consumer protection or general one. You have financial and economic controls, so litigation funding, etc. And you have procedural controls. So procedural controls that sort of mitigate to a certain extent a deviation from the individual litigation model and all the procedural guarantees that come with that. And you can and so a balance of the right of access to a fair trial and efficiency of collective redress proceedings takes place there. And you can find that in the ways the class is selected, you can find it in the way of notification, the control of the judge, the representative of the action, the suitability of collectors, etc. All to basically make sure that both parties are sufficiently protected while at the same time detracting actually from their right to an individual trial. Now, the idea is, of course, that member states that introduce collective redress do that to make civil procedures more efficient. So I would assume they would go for the most efficient option while keeping in line with the right to a fair trial, which requires, of course, a balancing exercise. And it's to my understanding, given how class actions or collective redress actions have developed in the member states, that these balances might be differently struck, and quite considerably, because initially representative actions, most of them, especially compensatory collective redress, is the result of events taking place within the member state with a particular in line with a particular situation, and so with different or particular procedural guarantees in mind. So in light of these considerable differences, I believe that there might be some wider scope to apply public policy in relation to collective redress, because the idea that underpins the Brussels system for individual litigation is not the same, the level of trust is not the same as for collective litigation. Now, if you look, for example, at class selection. Traditionally, yes, you have opt-in, opt-out, and the European Commission is pushing for opt-in, but you see various member states applying an opt-out principle, and there is also in literature suggested that in some cases it might be more beneficial in order to basically have efficient collective redress to have an opt-out rather than opt-in. So good for the defendant because it could actually settle all its problems in one procedure. For mass harm, it might be interesting to have this approach, but of course there's risk for group members of actually being deprived of the right to a fair trial, especially when they are bound by the decision without knowing anything of the decision. So you need stronger procedural safeguards, and it's there in relation to that that I believe public policy will then play a role. Notification is a publication in a national state gazette or on the website of a ministry enough? Should there be more different languages specifically targeting group types of notification, internet, newspapers, etc.? What is the level of control by the judge of the representativeness of the class? So, of course, not only the group member, also the defendant should be protected. What is the time to opt out? Differences exist considerably between the member states, but this is fundamental because if you can no longer opt out, you're bound by it. Or is there any possibility to opt out at a later point in time? And these will be evaluated in light of the consequence as well. If you're barred from individual proceedings, well, there's a fundamental problem with your right of access to justice. Right to be heard, some member states who particularly value the right of action, together with the disposition principle, there might be a problem there as well. So there is considerable scope for public policy concerns from member states that basically have no common, that do not have a collective redress tradition, or that basically have a very strict conception of procedural rights and want to see far more procedural guarantees than other member states. A particular problem that has been hinted at within the European Union is the Dutch system, where you have an opt-out sort of settlement or judicial procedure, so it's quite unclear what actually the thing is, but apparently it's working quite successfully, but it does not exclude parties from being bound against their will. And if you look at the notification requirements, it's all very vague, and there's certainly not a guarantee that everybody will be basically informed. And then the question is, should public policy interfere there? That depends presumably also on the national idea towards collective redress. But certainly there is an argument to be made that this might be less strict than regards to individual proceedings. Then I also have the problem of the effect on pending individual litigations. Very briefly, some member states provide for the automatic termination of individual litigation between class members and defendants. You can see the efficiency advantages there, but you can also see the deprivation of the right to individual litigation here specifically, because ongoing individual litigation is terminated and might be very problematic in line of an opt-out procedure again. Such automatic termination was also deemed problematic internally in the member states by the Court of Justice in Salis Sinuus in a different concept, in a different context, but still we could take that into account. So the question is, would then a foreign court refuse the public policy acceptance when raised? You see here that there are fundamental problems of the right to a fair trial. So I believe that there is an argument to be made for a less strict application of public policy in recognition of force in collective redress proceedings, because we have no common understanding of what it is. There is also no common standard of procedural design. And so the question is, if you're going to play around with heads of jurisdiction in order to make sure that collective redress is European-wide possible, not just in the place of the, for example, where the damage has occurred, but also in the center of gravity. So you take more parties away from basically their place of domicile. There will be more issues of recognition and enforcement. This combined with the liberal application of public policy, or more liberal application, there might be more opportunities for refusal, and this goes against the idea of the Brussels system, which is there actually to allow for the free circulation of judgments. Then The same goes with irreconcilable judgments, before I conclude. Also there you have various amounts of potential conflicts where individual litigation in one member state and collective litigation in another member state may coincide. There may be overlapping class members as well. The question is whether we can have irreconcilable judgments because you need identity of parties. This is not always very clear if there's a representative in one member state and a group member acting individually in other member states. But apart from that, there are also problems continue to exist depending on the actual mechanism, regardless of jurisdiction rules. Class selections, the relation to individual litigation, the same exists with lease pendants. There also you could have a problem. I just tagged it along because the issues are quite often the same. But there also, for example, the point of pendency. When becomes a collective redress procedure pending? When the representative introduces the action, when there is a certification of class, because you can opt in, opt out, so you don't know at which point you are part of the proceedings. So all these issues make it very difficult. So there is need for coordination between national systems, actually, in order to make this also work in a European context. Now, conclusions. So should we change the Brussels 1 bis regulations? I know there are many more issues involving collective redress and private international law, but we focus on regulation and coherence between collective redress and Brussels 1. We think it's better to first tackle the absence of a common culture of compensatory collective redress within the member states. Also to play around a bit with models because we are still in an experimental phase. We do not yet what's the best model. And so we think the first problem is not Brussels 1. The first problem is collective redress as such and the absence of a harmonized framework. Because even if you would now play around with jurisdiction, change it, there will always be problems and it multiplies basically the occasions where recognition could be a problem, undermining actually the goal of Brussels 1. So we think that first you need to tackle coherence within collective redress, both the approaches at EU level, sectoral or horizontal, but also within the member states. And this might either need a European initiative or spontaneous development. And then maybe later we could try and think then how to make this in a European way and how actually to, let's say, allocate jurisdiction in a way that would allow for a non-conflictuous cross-border collective redress culture. But that might take a while. So, and that's also, I think, why we do not necessarily approve of the approach taken in the GDPR regulation, where it already tackles it, but sort of doesn't really solve the problem and causes member states to introduce new mechanisms which might differ again. So first, collective redress, coherence in collective redress, and only later on we could talk about coherence between collective redress and the Brussels regulation. So I think this was the end of our reflection on the issues of coherence in the regulation of collective redress and private international law. Thank you very much.
Thank you very much indeed. I mean, it was certainly very rich, much more than that. And you also, I mean, I'm also very much obliged to you for being able to visualize the topic and the complexity topic that very nicely, because one really sees the complexity of the topic and how it is possible to blow somebody off the stage. Now, I would immediately open the discussion. I mean, in the cold, happily to, so that we have some space for the discussion. Perhaps just to get us started, I promise to be very quick. I just noted 3 things, and I would start with a question, and then we collect a number of questions from the audience. Now, just very quickly from the richness of thought, a very first remark on your paper at the beginning, horizontal and sectoral. I mean, I love the quest for unity and coherence and understandability. Let me sneak in rather a very cynical remark. Because, of course, everybody would like to have a horizontal, transversal, all-encompassing system. The only problem is that in the political realm, I would have understood it's a bit of a no-go. So from this point of view, having a salami tactics of having individual discrete areas which start multiplying might not be such a bad option if one wants to move forward in the political arena and just sell it through. And actually, within the sectoral ones, one thinks about the recasting or the new sectoral regimes. Actually, the best way forward in the political realm is to make class action and consumer redress part of the package. Right? Because then it comes as a part of the package of rights and obligations for the people in the sector industries. If one wants to have a head-on crack on a horizontal system for everything, I'm afraid one doesn't go far. The second point, or the second remark, which already was voiced by Janek at the end, it's really, I mean, and what was already in your presentation of, well, to be shy and the court being shy in Schrems and so forth. I don't think that the court is shy. I am shy, but the court isn't shy. But the problem was rather of a different nature, because one can start nibbling around at the edges in terms of international jurisdiction, but it doesn't go away what you just said. You don't have the substance, right? And from this point of view, I mean, when you read carefully, and you might wish to read carefully also the order for reference of the Austrian National Court, you arrive very quickly at the realization that yes, one is asking about standing in jurisdiction Article 16 to 18 of Brussels. However, there is no substance for collective action on the Austrian level. When you read through, you will find a sort of timid references to Sammelklage österreichische Prägung, which when you go through to the Zivilprozessordnung, you realize it's a simple aggregation of claims, which doesn't even change jurisdiction within Austria. It changes functional jurisdiction under, was it 207 or whatever, of the Zivilprozessordnung. It doesn't even change territorial jurisdiction within Austria, not to speak not having any substance. And that's really, I mean, what the humble Advocate General was rather saying. I mean, certainly wasn't implying that the court would be shy, but it's rather, I mean, through a nibble question of jurisdiction, you start changing the substance which is not there, and it's not there in the Austrian law as well. So there is your problem. Third remark on what Stephanie was mentioning and the heads of jurisdiction, 7-1 or 16 or 18 and so forth. There is something slightly paradoxical in all of that, because well, on the first side, paradoxical. I mean, you said assignment of claims, if we remain within the realm of assignment, and the fact that you cannot create jurisdiction, I mean, extra jurisdiction, you might perhaps retain jurisdiction, but not create a new one. Yet again, when you look back in Schrems, what was there, essentially creation of new jurisdiction, not a retention of somebody from India or Germany. But then, the paradox at the first side, when you had 7-1 as opposed to 16-1 or 18-1, actually, of course, when you think about it, you might have paradoxically greater protection for consumers if you were to aggregate on 7-1 than you have on 16 or 18, right? I mean, paradoxically, on the way you would think, oh, it's a special jurisdiction for consumers, it should to be extra protective, but it's also extra narrow. That's the problem. And when you think about the structure, you have the general jurisdiction, which of course everybody loves, but nobody ever applies. And then you have the special ones, which is 7-1, and consumer contracts is essentially a double special. So the special hoch 2, which then defines the narrowness. So paradoxically, if one wished to aggregate for consumers, you have more leeway on aggregation under 7-1 than you have under the special for consumers. And the last point, which is really a question to you, it's really from your picture, and especially from Cinzia's picture. It's sort of horizontal, sectoral, fine, harmonization, non-harmonization, soft law, hard law, whatever. But where would the member states fit in your vision of what is to happen? Because, I mean, what would happen and how would it operate if a member state really started proactively creating substantive rights? I mean, substantive procedure, but would have substantive foundation and would have tried sorted out all the questions you just mentioned and started allowing it, not necessarily in forum shopping, but allowing the fact, right? I mean, how would that fit into your picture of what is happening? So, and how then would it, in your point of view, what would be the dynamics on the European level? I mean, would it rather kick on the European level harmonization, or rather to say, oh, everybody goes to member state X and nobody cares about the rest? I mean, what would be happening and what's the role of the member state? Because quite realistically, yet again, if somebody wants to really start with all of that, I don't think starting on the level of a member state would be a very bad idea, or several member states, because then yet again, it's mutually non-exclusive and there might be an opening, but it's really a question. But please, whatever questions or whatever problems we have raised in the panel. Please, go ahead. Yeah. Do you have a mic? Yeah.
So I have a very short question for Cinzia and then a remark for the three of you. Cinzia, you were talking about the data protection regulation, and if I understood you correctly, in the data protection regulation there is, according to you, grounds for jurisdiction which could be used by the representative, the collective entities. I very much doubt this is correct. One thing is to allow the data subject to mandate a collective representative as an association of an entity to represent him, and another different thing is to open up the residence of the data subject as a ground of jurisdiction to be used by the entity. So you have the tool, you have the possibility of representation, but this does not entail automatically that the entity is allowed to use neither the grounds on the regulation, the data protection regulation, nor even the consumer grounds provided for by the Brussels 1 bis. And then the other thing is Brussels 1 or the changing the Brussels 1 bis or changing collective redress. I don't even think that this is the issue. The issue is rather how to organize consumers, how to organize them practically, simply, so that they can, for instance, you could simply use the domicile of the defendant as a unique ground for jurisdiction, provided you allowed consumers to go to one representative entity in one country. Nowadays, as far as I know, it is even impossible for a Spanish consumer to become a member of a French association. So it's rather a question of how to solve practical issues. At the level of jurisdiction, I think that or in general, I think that there is something missing in the debate, and these are the business. If I recall, when I was studying, the idea of protecting the consumers at the European level had not only to do with consumers, but rather with creating a level playing field for businesses. So from my point of view, if you give the consumers the tool of a collective redress, then you have to create a balance with businesses, and this could be and if you give consumers the possibility to opt in or to remain out, even more, in the sense that, well, consumers will have this possibility, not even creating finality. So again, as Janek said, there could be more litigation open up by different consumers. So I think that at least at the level of the jurisdiction, you could balance it by giving just one ground for jurisdiction for the action filed by the representative entity.
Thank you very much indeed. You wanted the floor?
It's a very quick question. Is anybody happy with the decision in Henkel? I mean, let's not talk about Schrems, let's just talk about Henkel. Does anybody find that the solution satisfactory in terms of one being forced out of the consumer head and lose the fact of the existence of the representative organisation in the role taking the consumer head away? That's one aspect that one might find problematic in terms of disincentivizing recourse to common redress. But then the next aspect is where does one then go? One bypasses Article 7.1. The Advocate General Bobek seems to think that was maybe not the right solution. We should have landed in Article 7.1. I'm not sure I agree with that. But we bypass 7.1 and we end in 7.2, which seems to be, it's one of the most complex provisions in the regulation, but it's terribly difficult to apply and doesn't really produce adequate solutions. So for all those reasons, Henkel seems to me to be the place to start. And maybe Schrems with its consumer-friendly interpretation of consumer, albeit with a very narrow effect, might open at least a crack in the door to revisiting some of the issues in Henkel. But that's my question.
Any other questions for this round? Please, go ahead. The microphone over there to the left.
Thanks. Alex Layton from London. It seems to me that we are going to continue to have problems until we have some consensus on what the purpose of collective redress is. Is it to obtain access to justice for a plurality of consumers who have allegedly suffered some particular wrong? Or is it to rein in business from its excesses in the product liability field or elsewhere? In this regard, if it's the latter, you're going to be more likely to want to go for an opt-out type of procedure and then address the problems that gives rise to, particularly in respect of claim preclusion and the need to have adequate notification to potential class members, unnamed class members on the one hand. If it's the former, then you are going to be looking more at the bringing together of jurisdictional rules in various different options. And I entirely echo Andrew's point about how do you get there and do you do it by defining the classes of consumer and so forth within the current Brussels I framework. I must say I have sympathy with the idea that a fresh instrument is the way to go for collective redress rather than trying to force it into the rather unnatural straitjacket of the existing rules in Brussels I. But those are just some thoughts really about what do we want to achieve rather than how do we get there.
Thank you very much indeed. Shall we start in the same order as the papers were presented, if you have any remarks?
Yes, thank you. So as to the horizontal approach and where member states, if their role in this and the development and evolving on the framework on collective redress, I do think that, and as I think I've already said, that the sectoral approach is step by step, and it is useful to see the reaction and the impact on the national legislation. So I do think that first. And as already said by the other two speakers, the consensus is needed, and the national legal orders need to provide collective redress as a similar way, and first as a consensus that this is an effective means for protections, and then create a framework that may present similar standards or not, and then move, as the last speaker said, to think about private international law issues and collective redress. But first, shape a collective redress. Then probably I did not explain very well about the Article 80 of the GDPR regulation, because there's in this article a sentence that says all the special fora established in that regulations may be invoked and applies to the representative entities. I was just referring to that special fora that are new and different from the Brussels I regulation. So I was just thinking about it, and so then I took this extension of the special fora to representative action to say, look, we already have a solution, or just a hint to find a solution and collective redress and private international law issue and the jurisdictional regime. So I think that's all from my side.
Thank you.
Thank you.
Stephanie, Janek, if you want to react in a way.
Shall I go first? So I think I would agree with you. Well, it relates again to Professor Dickinson's point on whether, I guess, Henkel is satisfactory. If on your point on whether there might be more leeway under Article 7.1 than under Article 6 or Article 18.1. It's one of the issues I tried to point out that I think it's right. There's a doubling of criteria, let's say, for representative actions under Article 18.1. First, the need for a contractual relationship, and second, this idea of the existence of a weaker party. Or if we take this teleological interpretation of Article 18.1 to look at, okay, what's its purpose? To protect weaker parties to litigation, predominantly consumers who are lacking various types of power, litigating power, bargaining power, etc., etc. And it relates to the question on on Henkel. Is Henkel satisfactory? Yeah, maybe not. I mean, I think it's a difficult question to answer, and maybe it's one of the correct starting points to start to think about really the position of representative entities in each of the member states. But yeah, I have to say I'm not entirely sure, but I would like to think about it a bit more. Marta, with regard to your question on the GDPR, I think I would agree with you that there's nothing in Article 80 as such that would suggest that representative entities or representative organizations under Article 80 can rely on the jurisdiction of data subjects, their habitual residence. But okay, it's still very early and we have some time to see how exactly the case law will develop in this direction. And finally, to your last question, the issue, of course, at a practical level is how, when we're talking about consumer protection, how best to organize consumers. And the approach seems to be at the moment, at least under the Commission's 2018 proposal on representative actions, well, it's pretty unclear with regard to cross-border actions, but what seems to be indicated is that consumers should rather be joining a representative entity or being represented by a representative entity within their own member state. And then it's this representative entity which can take action cross-border or join together with other national representative organizations. Is this satisfactory? Well, okay, again, how do we organize this situation where we have consumers in one member state attempting to join a representative entity in another? I mean, in practice, maybe it shouldn't be that difficult, but we see at least some discussions. Some discussions. We have some websites we've noticed with regard to actions under the GDPR. It's also the same that you have consumers joining a representative entity within their member state, which then takes the cross-border action.
Yes, I'm just going to address in the order of proceedings the points I like to address and can address. So, yeah, the balance with business, to talk about that a bit, because, yes, I've noticed that when we talk about consumers, it's immediately consumers are good, business is bad, and consumers is weak, and business is all powerful, and then we should address the balance. And I'm always a bit skeptical towards that because there are different types of consumers, also different types of businesses. The only thing, I haven't made my mind up yet, but I was wondering if you as a business are on the market throughout the European Union and you have like customers everywhere and you are considerably big or big enough like Facebook, do you need also protection as a because for example, the representative bringing a case or might be much less powerful. So I would not, the idea that by facilitating cross-border redress, businesses, the different types of businesses, small and medium might need protection, but then you need to distinction, the same way we have with consumers, it's a problem to within a category to start making distinctions. So that's a very good question. The question is there, who will be targeted by a cross-border collective redress action? When should something like that be started? Because you might also have criteria of suitability, representativeness you could sort of insert there, and that would then make it sort of that you only target like undertakings that might be able to handle that or say deserve it to be treated like, whereas you for undertakings that could not handle that, you sort of make sure that it's limited in scope. But that's an entirely a political question in a way. Happy with Henkel. I found Henkel interesting because it's sort of, it was about unfair contract terms and it sort of changed, we changed contract into tort in matters of, for that purpose. So we had also a lot of discussions on that, whether that would actually a way to go, because it's basically trying to have sort of an action within the current system. So maybe within the system, it might help to facilitate. The question is whether how you want to go about it, if you can really redesign the system. And I must admit that many possibilities, and I haven't really made up my mind yet. So Henkel is a very good idea to start and see what's the problem within, and then how to move forward. I have no idea at the moment whether the contract becomes storage approach, whether that kind of let's say deviation is necessary if it's about basically a problem with a whole bunch of contracts, so you can't just have like the contract basis, but then with all the problems that come with that, so that will also need to be addressed. And that which I'm very sympathetic to maybe a different instrument, because collective redress and cross-border issues are probably the issues of jurisdiction of play are different from an individual litigation, and so that if you would insert them in the same instrument, it might sort of completely undermine the idea of that instrument. But at the same time, the problems with relationship between collective and individual decisions might continue to exist. So I don't know whether this might solve all the problems, because you can still have an individual litigant also potentially being a class member, and then problems might continue to exist. Yeah, that was it for my part, actually.
Thank you very much indeed. Any other questions before the? I mean, I'm not dodging your question, but yes, please. Burkhard Hess and then von Carsten. Sorry. Yeah, please go ahead.
Just to take up what you said in your fourth remark concerning the three presentations, member states are already making their national legislation which profits from the unregulated situation at the European level. And this is, of course, the Dutch Act, which attracts litigants from other EU member states and which shall operate under the Brussels I system. And I'm not sure whether this is a very stimulating and good development, because, as we have heard, Brussels I is not made for these different collective redress mechanisms. And in this respect, I found it quite interesting to look at the public policy defense, which shall be strictly exceptional under the Brussels I regime, but in case we have not an equal level field, it might be that it has to be applied in a broader way. You made it in your conclusions in July regarding the Charter and the national standards, national constitutional standards, and I would say maybe we have a similar situation here where is more leeway for national traditions, values, because we don't have a consensus at EU level. And finally, it is not a new situation. Collective redress has always been in the Brussels I regime. Just look back to Min Potast Alsace. Who were the plaintiffs? It were not only the Dutch farmers, it was also a foundation for environmental protection. So it started from the very early beginnings. It could be accommodated to some extent, but still we have problems here, and only focusing at consumers would also not be enough, finally. Again, Min Potast Alsace, the plaintiffs were farmers, but they needed protection. And if you look at investors' financial disputes, we have again an area where we have mass claims, huge mass claims at the moment, and a high competition in the European marketplaces. And even in the Dieselgate cases, there are not only consumers involved. Many diesels have been bought and are used by businesses.
Thank you very much indeed. Gert van Kasten?
Thank you very much, Chair, and thank you for those presentations. My question is probably, it links actually to what Professor Hess just said about this first question in particular. Do you think when you look at what you all mentioned, the GDPR, collective redress, but even the account preservation order, for instance, is this discussion one about horse and cart? Do we use European private international law, especially civil procedure, to kind of, as a jack to make things move at the substantive law level? And assuming that we do you think that the Commission or the Member States have a strategy or a shared view on whether we should and how we should be doing that? This question being addressed to Cinzia. Anyone who wants to pick it up.
Well, because you might not get an answer. That's
which indeed probably enables you all to dodge it. I shouldn't have said that.
Indeed.
To the chair in that case.
Any other questions before we close the floor? And because the constitutional guaranteed right to lunch is horizontally directly effective. Yeah, please.
Yeah, to the same debate, what about procedural autonomy? If we are granting procedurally or protecting procedurally European rights, European granted rights, leave the member states make it within this context.
Yes, sure, thanks. But starting from this last point, procedural autonomy is, and I mention it because there's a conflict of interest in developing, I think, procedural means, because on the one side we have the procedural autonomy of member states, and on the other side the protection of rights, of individual rights. Whether under the GDPR, if I well understood the question on collective redress and GDPR, and if it brings us to the substantial level, I think that I don't know if I well understood the question, Arvit, but I think that under this GDPR we have a form of collective redress, okay, and that's all. I don't remember. Sorry, I got lost thinking about the procedural autonomy. So I.
If you have anything more.
I mean, just a quick remark from my side. I think with regard to the question of horse and cart, I think with the 2018 proposal of the Commission, we have this idea of one mechanism of collective redress based on this representative action model, which should exist in coexistence with other mechanisms already existing within member states. And our idea is not to make us, with regard to collective redress or cross-border collective redress, is to let's see what would happen with this proposal within the member states if there's some not spontaneous harmonization or coherence, but the idea that this might lead to coherence, as we said, it might take some time, but before we then intervene to try to identify before we intervene making further amendments to Brussels 1 bis, which of course will not come anytime soon anyway, or with another instrument from the EU legislator to again be implemented in the member states with regard to issues of jurisdiction, recognition and enforcement, recognizing of course that this might take some time. Yeah, go ahead. I had some other. No, please.
Okay. Yes, that the focus should not be on consumers. Yes, absolutely right. I can, for example, think of my member state of origin, not domicile, where actually now there's also the opportunity to have externality collective redress mechanism for consumers, representative collective redress to also small and medium enterprises. So yes, this is moving, and of course this should also be addressed. It's not just about consumers. Also others might need it. Then with procedural autonomy, which is a kind of a favorite topic of me, to me, actually, if the EU decides to legislate, it's the question of competence. Like, autonomy is where the EU has not legislated. So if the EU legislates, yeah, it's they can do within the constitutional restrictions whatever they want, basically, whether you agree or not. But yes, I'm very much opposed to the argument of procedural autonomy as resisting EU intervention, because autonomy is only there where the EU has not intervened. And then the horse and the cart, yes. We had this discussion as well, and yeah, could you, by allowing circulation through private international mechanisms, you would sort of also stimulate the creation of cross-border of collective redress within member states that do not necessarily have it. That's another approach, and that could also be valuable. But when we were going to the literature, the approach we've encountered most is we need to change it. And we thought providing a different perspective here, saying wait a bit and do collective redress first. But that's also a viable option. It's but we need time, I guess. And
just very three quick remarks on the questions, and then time we don't have. Is anybody happy with Henkel? I am, because it's established case law of the court. But that being said, however, of course, I mean, if one had a possibility to have a fresh look at it, one had a different look. The problem with Henkel is it partially answers the question or something which you believed I said. I didn't intend it that way. Schrems should have done 7-1. No. It was an objective observation of the latitude, and it's partially your answer to Henkel, the latitude that is allowed on assignment of claims under 7.1 as opposed to 18.1. And when one looks, I mean, more recent case laws such as flight right, such as the assignment of claims by under the 261/2004 regulation on passengers' rights, that's all possible. And the assignment possible also with regard from a physical person to a legal person, right? All that is by now part of 7.1. I wasn't saying that you should have done that and not that. No. It was simply an observation from those two grounds that in terms of what a consumer association might wish to do, 7.1 is much more open. That was just an observation. The other, I mean, that was the second point, and the third point on the GDPR Article 80 and so forth, I think as far as recall, Cinzia mentioned it somewhere towards the end, ID Fashion is a running open case from Germany, where the question number 1 is about the standing of a Verbraucherzentrale given to that consumer association under national law. Now, the question there is posed slightly differently. Is EU law opposed to that? I mean, EU law meaning the directive by now out of legal force, but still applicable in the case at hand. And then comes Article 80 of the GDPR, and the question of how does it link or does not link in there. But understanding of association in generally, and partly the answer to the Henkel, yet again, a huge difference if, scenario 1, the EU law does not oppose it, and member states give standing to consumer association. Scenario 2, well, EU law itself gives standing or opens up space for consumer association. And scenario 3, national law says nothing, EU law says nothing, and then comes somebody and says on the basis of Article 18, all Verbraucher associations shall have standing. These are 3 very different scenarios. And I don't think all of them, I mean, from this point of view, it doesn't matter that much whether it's 18.1 or it's 7.1 or 7.2, right? It's just yet again a rule of procedure which says nothing about standing of consumer association. Of course, one may read into those provisions whatever one likes, but part of the thinking there are the ripple effects. From the point of view that, okay, one is looking at, I mean, of course, it's heretical to say it here, but a very discrete area covered by Brussels regulation, consumer contracts, okay? And if you throw a stone in there, how then is one supposed, okay, you help somebody, you do good, whatever you like it, how then is one supposed to limit those general statements with regards to all the other provisions of Brussels regulation, which is a transversal regime for private international law? So, of course, I mean, if one wants to be inventive, you can write into 18.1 whatever you like. But the problem is then, okay, systemic horizontal coherence of the system, because then one starts having a system when 18.1 is a completely out of the window from the rest of the regulation, and so forth, right? Because assignment of claims, it's a transversal mechanism, isn't it? So, but those are just few questions. But I'm getting the notion that the director is getting a bit nervous because there might be lunch.